with your host, the distinguished New York lawyer, author, and lecturer, Alan Schnurman. Each week, Law Line will bring to you the most knowledgeable experts in the field of law today. Mr. Schnurman and his guest will be taking your phone calls during the broadcast. The number for you to call is 247-8090. And now we introduce today's guest and our host, Alan Schnurman.
Welcome to Lawline. Today we're going to take a look at the Small Claims Court and how it works for you. Our guest is the Honorable Israel Rubin, Administrative Judge of the Civil Court of the City of New York and Justice of the Supreme Court of the State of New York. Hello, Judge.
How are you, Alan?
Judge, for the opening question tonight, can you tell us who can bring a claim in Small Claims Court and how much can they sue for?
Anyone can bring a claim. A party under 18 has to bring it by a guardian or a parent, and you can sue for any amount up to $1,500.
Okay, what if I'm a small businessman? Can I still sue in Small Claims Court?
You can if you're not a corporation. If you are a corporation, you must use the regular parts of our court. You cannot use small claims.
Well, what about the mom-and-pop grocery store? Although we incorporated because our lawyer told us that was the thing to do I still have to get a lawyer to sue for a bill of $100 or $200 or $300 that my vendor owes me?
Unfortunately, yes.
Okay. Well, let me ask the opposite of that question. What if I'm being sued and I'm still that mom-and-pop grocery? Do I have to get a lawyer to defend me?
No, in that event, you do not. To take the positive action, you do. But if you are sued and you are what you refer to as a mama-papa type of corporation, you do not need the services of a lawyer.
Okay. And how do I go about it? How do I start a small claims court? Let's assume I know nothing. Where do I start? Where do I go?
Very simple. You just go to the clerk's office in one of the various boroughs that we have, in the 5 boroughs. In fact, in New York County, we have 2 small claims offices. You just go to the clerk's office, you tell them your story, you sign a complaint, you pay a magnificent sum of $4.55, and that institutes your action.
Well, you say you tell them your story and you sign a complaint. Who writes out the complaint? Do I? Does the clerk?
You either can do it or the clerk will do it for you, and then you sign it. It's a very simple procedure.
Well, then what happens? How does the defendant, how does the party that I'm bringing my claim against, how does he know about it?
Well, what happens is the clerk takes that complaint and mails it to the defendant by certified mail, return receipt requested.
Well, what happens if he doesn't go to the post office to pick it up?
Well, there are 2 problems. If he just doesn't go to the post office, there could be a time that would come back to the clerk's office and you would have to serve it personally. However, if the post office or the mailman marks on your letter, on the court letter, that it was refused, that the party refused to accept it, that is the equivalent of service.
Okay. Now let's assume I'm a claimant. I know nothing about the legal situation. All I know is, let's say, I had an automobile accident, and my car was damaged, and it was the other guy's fault. And I have no insurance that covers me. I don't have collision. All I have is a car that it's going to cost me $400 to repair, and I don't have the $400 to fix it. I bring an action against the party who hit my car. How do I prove my case, Judge?
Well, you first have to go in and tell your story as to how the accident happened. Hopefully, the other side will have insurance. And what we usually try to do, we try to settle it. Either a judge or an arbitrator will try to settle your case. However, if it cannot be settled, you tell your story. The problem you pose to me is you cannot afford to fix the car.
Many of our viewers cannot.
Right. Because the usual instance is that we require a paid bill. The first thing I should tell you before we even go into that is you have a picture of your car to show to the judge. Because at least looking at a picture we can tell something. And then you should get a mechanic, someone that knows something about cars, just to come in and testify as to what it would cost to repair that car. And then it's up to the judge to make up his mind or her mind as to just what the verdict will be.
Like I'm sure happens in many instances, let's assume I tell my story. And then all of a sudden the defendant tells an entirely different story than what happened. I mean, what can I do in that circumstance?
Well, you just tell the truth, and it will be up to the judge or the arbitrator to decide which story is more credible. And that's the only way that we can tell.
Should I try to bring witnesses with me or a passenger in my vehicle?
If you have witnesses, of course you bring them. You have a passenger, sometimes there's an outside witness. You bring those witnesses because it's not the quantity, I just want to impress that upon you, it's the quality of the witness that will control as far as the judge is concerned, and if that party is what we refer to as an interested witness.
Now, who hears this case? Is it a judge? Is it an arbitrator?
Well, our small claims court has been very successful due mainly to our arbitrators. But we have a judge, sometimes two judges, and many arbitrators that are present. And usually the arbitrator will hear your case. And an arbitrator is an attorney that has been in practice for a minimum period of 5 years who volunteers his time or her time to the court.
Well, you use the expression, usually an arbitrator. If I bring the action, or if I'm being sued in small claims court, do I have a choice whether to select an arbitrator or a judge?
Yes, most definitely. You have that choice. Usually, however, with a judge, there are only 1 or 2 judges serving in the evening, and there are many, many cases. And it will take a lot faster and be more expedient to have an arbitrator decide the case.
Are you saying that it may not even be heard on that first night in which I appear because there might be 10 cases ahead of mine?
If there are many, many cases, and we usually work far into the evening, it's not unusual for us to work up to 12 midnight.
Oh, boy.
But if we can't reach your case by that time, then that case will have to be adjourned if you want to go before a judge.
Is there, well, you're talking about evening small claims.
That's right.
Here in Manhattan, is there also a time in the day that you can go?
We have a time every other Friday, but that again depends on the judge whether you will be assigned to day court, or if, let's say, you are a senior citizen and for some reason cannot come out in the evening, we will permit you to come into day court.
Now, let's assume I do select the arbitrator. What's the difference between selecting an arbitrator and selecting a judge? Is it exactly the same, or are there differences?
Well, there's the same. It's the same with the exception of one thing. You do not have a right to appeal if you have a decision by an arbitrator. You can appeal a judge's decision.
I see. So if I don't like the judge's decision, there's no problem. I can appeal it to a higher court. How do I do that?
Well, you usually need the service of an attorney. It's very, very involved. You have to file a notice of appeal with the clerk, and your case will go to what we call the appellate term of the Supreme Court of the State of New York. I can just say this to the viewers, that an appeal is usually granted. When I mean granted, I mean a decision of a judge is reversed in very, very limited instances, because the appellate court applies what we refer to as substantial justice. And if they think the judge did what we refer to, as I said, substantial justice, that is the end of the appeal. So it's very, very limited as far as the times are concerned when an appeal will be granted, to the extent that a decision will be reversed.
I got a letter from a viewer, and they asked me to ask this questions of you, Your Honor. He said he brought a radio into an electronics store. He had purchased the radio there a few months earlier, and the radio wasn't working. The electronics store manager said, you tampered with the sound and we're not going to replace it. Well, he spent over $100 for the radio. He did not tamper with the sound, he said, and he wants to bring him to small claims court. But he wants to know, how is he going to prove his case? Well,
the first thing, if you have a radio and it's a table radio, you usually can bring that into court and we'll put it right on in court. That's not unusual. And then you just tell your story, and again it becomes a question of credibility between the storekeeper and the party that did the purchasing of the radio.
well, should I try to bring any type of witnesses with me, or an expert, or somebody who knows radios?
Well, of course, if you can get an expert, you bring that expert in. But if it's a $100 radio, an expert will usually charge you money to come in to testify, unless it's somebody that you know very well.
Well, what if it's a big store, like one of the department stores? I know they're going to have a lawyer.
Yes.
Should I be worried about that? I mean, I don't have a lawyer.
Whether you have or do not have a lawyer, it means very little in small claims court. And you really do not need the services of an attorney in a small type of case, and we refer any case up to $1,500 as a small type of a case.
Because that is the idea of small claims court.
That is correct. We don't want you to spend money for lawyers. We hold court in the evening so you don't even lose a day's pay. That's the whole idea of the court.
Another question I have for you, it came in again from a viewer, and it had to do with work that was done in his home. A contractor came in, did some work on cabinets, and wanted to be paid. But the viewer said that the work really wasn't up to the quality that it should have been. Well, the contractor sued him in small claims court, and now they have a date to come down. And he wants to know what he has to do to defend himself in small claims court so he doesn't have to pay this contractor for this, what he calls shoddy work.
Well, hopefully that party will have a contract to show to the judge, indicating exactly item by item what was to have been done. He or she will show that contract to the judge, tell the story, exactly what he thought that he was supposed to get as far as the improvements to the house are concerned, and we will hear the defendant's point of view, and then again it becomes a question of credibility, and the judge will decide whether you had value for your money in accordance with the contract, be it written or oral, or whether the contractor gave you exactly what was supposed to be gotten as far as you were concerned.
Judge, let's take some calls. Hello, you're on Law Line with Alan Schnorman and Judge Rubin.
Yes, can a disabled person file by mail, and can a disabled, or actually any person for that matter, sue for expenses for getting down there? In other words, it'd be cab instead of subway, and can they...
Talk a little slower, you're talking very
louder.
Fast.
All right, I'm sorry. Can a disabled person file by mail, and can they also sue for expenses for getting down there for the taxi cab since they can't take a subway? Or for that matter, can any person also sue for expenses?
Now you're asking for the expenses of actually going down to small claims court, is that correct?
Yes, for a disabled person, or actually anyone, and can they sue for lawyers' fees? In other words, can they sue for anything other than the $30 or $40 that...
I think we have the question, Judge.
All right, let's take the first question. Can you do it by mail? Unfortunately, the answer to that is no. But you do not have to appear in person. If you authorize anyone to come down and take out the summons for you, that will be sufficient. So mail really isn't necessary, and it doesn't stop you from going to our court. Unfortunately, as in any other case, we do not give expenses as far as transportation is concerned, and we do not give attorney's fees, and that applies to every case as well as small claims court. There are only very, very limited instances under the law that you can obtain attorney's fees.
Okay, let's take our next call, Judge. Hello, you're on Law Line with Judge Rubin and Alan Schnorman. Can we help you?
Mr. Schnorman, congratulations on your wonderful show. Mine is a voice you probably know. However, I'm going to ask a question, and that is regarding barter. If you have barter and the person, in other words, you advertise, and the other person reneges on the barter, can you sue the people that have not followed through? If you have given, say, advertising on a television show, as an example, in exchange for barter, and the other people don't come through.
You can sue for anything in small claims court that can have a money value. You can only sue in small claims for dollars. So if this barter agreement, you can place some type of a monetary value to it, of course you can sue. Again, up to $1,500.
Judge, would it...
Thank you very much.
Okay. Judge, would it be correct if someone is suing for barter, and barter is more and more common nowadays, I assume what they would do is they would say, well, if I had not had this barter arrangement with you, I would have charged you $50 instead of receiving your services or your product that you were going to give me. So couldn't I go to small claims court and take out the complaint for $50, which would have been what I would have received from you had we didn't have this barter system?
Yes, that can be a loss or a measure of damages as far as you're concerned. And if you view it as a measure of damages, you can sue for it.
Judge, I see you brought with us a pamphlet, and it states a guide to small claims court. Can the camera pick this up? And under that it says New York State Unified Court System 1982, and I see it has the Chief Judge Lawrence Cook's name on it.
That's correct.
Can you tell the viewing audience what this book is?
Well, it's a booklet we give to every claimant that comes into the court. In other words, when you come to the clerk's office to take out a summons, you will be given a copy of that booklet. If any of your viewers would like to obtain a copy of the booklet, all they have to do is write to me, Judge Israel Rubin, R-U-B-I-N, at 111 Center Street, New York, New York, 10013, and I'll be very happy to send them a copy.
And that book tells the claimant basically what is in store for him?
That tells the claimant everything that there is to know about small claims, from the taking out of a summons to an appeal, possibly, to the enforcement of a judgment.
Aha, that was going to be my next question.
I anticipated that.
Let's assume I've gone through the whole process. I've listened to the show tonight, I presented my claim, and because of your advice, I was victorious. And I came home to my wife and said, I just won $250 in small claims court. And she said, so how come you didn't buy the groceries? And I said, well, I didn't get the check. How do I collect that sum, Your Honor?
Well, let's take it step by step. In the so-called property damage or fender-bender action, there is usually an insurance company. You take a copy of that judgment, send it to the insurance company, and the usual case again, within a few weeks you will receive a check. If there's a department store involved, the same thing will happen. The problems that we have is when there are individuals suing individual, and the claimant does not know of any assets. Then what you do in the City of New York, you either obtain the services of a marshal of the City of New York, and you just look in the yellow pages of the telephone book, and there is a section called marshals. You get the services of any one of those marshals, give him a copy of the judgment, and that marshal will attempt to collect for you. The same is true of the sheriff. And the sheriffs usually work out of the county clerk's offices. There is one for every borough, and they will try to collect for you.
Okay.
And they are successful in many, many instances.
Which brings me to my next question, which I received by mail from a viewer. That happened, they won, they gave it to the marshal, and the marshal couldn't collect anything. But this viewer knew, because they knew the person they were suing was a local person, and they knew that the person had assets. He lived nicely, but everything was in his wife's name. What can they do?
Well, you say a party lived nicely, that party has a job, the salary can be garnished. By that I mean, if you find out where that person works, in a few minutes I'll tell you how to find that out. If you find out where that person works, again you give that back to the marshal, and the marshal will serve papers on the employer, and you will eventually obtain 10% of the party's salary until the full judgment is paid. What we have in our court, and this is something relatively new, we have an information subpoena. If a judgment is unpaid for 30 days, you go back to the clerk's office, and that clerk will issue an information subpoena, which is again mailed to the debtor, and the debtor will have to answer many questions just as to where and what the assets of that particular party are. And also we have an information subpoena for third parties. If you send it to banks in the area where the debtor lives, the banks will have to answer whether there is an account in that party's, or if you desire, in the wife's name.
Your Honor, someone from your staff told me that years ago you sat as a small claims arbitrator. Can you tell?
That is correct. I was one of the original arbitrators when small claims started 30 years ago. When I say small claims started, I'm talking about the evening division of small claims. I was one of the original arbitrators during the first week of evening arbitration.
Well, if you think back to those days, do you remember any interesting stories that you can relate to our viewers?
Well, when I told you a little while ago about bringing a radio into court, I remember one of the first cases I had involved a canary that allegedly died as a result of some feed that was purchased from a pet store. The claimant came in with a box and told me the story, and then said, "Look, Judge," and opened the box, and there was the dead canary. These are the things I'm faced with. The other story I remember, and it's something I remember to this day, only because I originally thought these things only happened by joke tellers up in the board circuit, and I remember there's a comedian that tells almost an identical story, and it happens to be true. There was a party suing a dentist, saying that the dentures that were made for him by the dentist did not fit, and the dentist swore on the Bible that the party came back 10 times and that denture fit. There wasn't a thing wrong with the denture. It was finally drawn out from the claimant. He wasn't talking about the denture fitting in his mouth. Evidently, the dentist gave him a container for the denture to be placed into at night, and the denture did not fit in the container at night, and that's what he meant when he said it didn't fit.
Well, that's certainly a good story, Your Honor. And with that, let's take our next call. Hello, you're on Law Line with Judge Rubin and Alan Schnorman. Can we help you?
Yes, hello. I wanted to ask the judge if with the tremendous volume of cases that you get in small claims, do you think that government-run court system is the best way to resolve matters of this kind? Do you think there should be some sort of private means that people should try to use to resolve problems like this?
Good question. Your Honor?
Well, first of all, people should always try to resolve their problems in an amicable way. Talk to the people involved, and 9 times out of 10, you can settle with the party that you have a dispute. Barring that, don't forget this is a country of law. Arbitration is what we refer to as an alternate dispute resolution system. It's not technically a full-blown adversary system. We utilize the arbitration system as a method. But I just want to tell you that the Small Claims Court, as we have it in New York, has been one of the most successful courts in the world. I have judges visiting me from almost every state in this country, indeed from other countries in the world. Just the other month, I had the Chief Judge of Brazil, the Chief Judge of Fiji, the Chief Judge of Australia visiting our Small Claims Court with a view towards putting the same type of court into being in their countries. So we must be doing something right.
Okay, let's take our next call. Hello?
Hello, Judge Israel.
Yes, sir.
Hi. I have a little cable TV show, and I sell video cassettes of the show to guests that have been interviewed on it. Recently, I had a guest who had agreed to buy a video cassette before coming onto the program, and 3 months have elapsed with a lot of unreturned phone calls. His attorneys now say that he denies the claim, that he never agreed to buy the video cassettes. Now, I have the video cassettes. I have no oral contract, no written contract. Should I go to Small Claims Court with the video cassettes and demonstrate that he did, in fact, consume the services?
Well, one thing I cannot do for you or any of the viewers is give legal advice. That you will have to obtain the services of a lawyer. But if you think you had an actual contract with that party, you go into court, tell your story, and the judge or the arbitrator will decide who is correct and who is not correct.
Can you give me a ballpark guess on how this would turn out?
Oh, I think that's an unfair question.
Unfortunately, I can't do that.
Thank you very much for calling. Hello, you're on Law Line with Judge Rubin and Alan Schnorman. Can we help you?
I would like to ask the judge whether it is necessary to have a signed receipt for merchandise delivered to an individual, or whether you can proceed into Small Claims Court without this signed receipt.
You don't need a signed receipt, although, of course, if merchandise is delivered or picked up, it's best to have that receipt because that's actual evidence. To go into court, you don't need it, but then it becomes a question, as I stated before, of credibility, and the judge or the arbitrator will decide who is telling the truth.
I see. Thank you. I would like to add that in the industry that I'm speaking of, deliveries are made without signatures.
Well, you just tell that to the judge that it's the custom in that particular industry that there are no signatures on receipts.
Thank you.
Thank you for calling. Your Honor, how many claims are heard a year in Small Claims Court here in the city?
Well, we have roughly 60,000 cases a year in the city of New York. So you figure that out, it's roughly 1,200 cases a week. That's a lot of cases.
That's a lot of cases. Now, from what you said, there's a Small Claims Court, at least one, in each one of the 5 boroughs.
That's correct, Alan.
Now, what happens if I purchase something in one of the other boroughs other than Manhattan, or let's say even in Nassau or Suffolk County, and I have a claim against that particular store, and it's under $1,500, what Small Claims Court do I go to? Do I go to the one here in Manhattan? Do I go to the one where the store is, let's say the store is in Brooklyn or Queens? What do I do?
Well, in the city of New York, it's very easy. If you have a claim against someone in the city of New York and you live in the city, you bring it where you reside, usually, and we have jurisdiction of the entire city. We do not have jurisdiction outside the city. So if you have a claim against someone in Nassau or Suffolk County, you must go out to the Small Claims Court in Nassau or Suffolk County to bring the suit if you desire to use small claims.
I see. And there's a Small Claims Court in every county in the state?
There's a Small Claims Court in what we refer to every district or county in the state of New York.
And those courts also have arbitrators and attorneys?
Most of them do, sir.
And judges?
Yes, most of them do.
About these arbitrators, what criteria do you, as the administration, use in selecting the arbitrators?
Well, the arbitrators apply to me, the attorneys apply to me. What they have to do is, first of all, send in an application, indicate to us that they've been in practice or been admitted for a minimum period of 5 years. We then send that application to the New York County Lawyers Association. The New York County Lawyers Association does an investigation on that particular attorney and then tells us whether that attorney can be utilized as an arbitrator. And we then put them on staff. We give them an orientation meeting. By that I mean we devote an entire afternoon giving them some of the basics as far as the law is concerned, that on some of the cases that they may come up across when they're in small claims court, and then from time to time we give them orientation sessions.
Thank you very much, Your Honor, for appearing on Lawline.
It's been a pleasure being here, Alan.
Once again, the tax deadline is almost here, and most of us are in the process of accumulating data for our tax returns. Join us next week when we're having Robert Taft, a tax specialist, to answer any of your questions and give you a few helpful hints. Keep in mind that starting in March, Lawline will be moving to a new time, 7 o'clock, Friday evenings on Channel J. We hope to see you next week at the same time, which is 6 o'clock next week. This is Alan Schnorman, and goodbye from Lawline.
You have been listening to Lawline with your host, New York lawyer Alan Schnorman. For further information on this week's topics or any other questions you may have, you can write to Mr. Schnorman at Lawline, 63 Wall Street, New York, New York, 105. If you prefer to call during regular business hours, the number is area code 212-432-9111. Mr. Schnorman will be back with you again next week at the same time. This is Bill Burton Show speaking.